Please be seated. The sitting is resumed. I now invite Mr. Paul Reichler to address the court. You have the floor, sir.
Mr. President, members of the court, it is, as always, an honor for me to appear before you. And it is a special privilege and a responsibility to appear on behalf of the Gambia in this historic case. We are very much aware of its significance for the parties, for the Rohingya people, for all parties to the 1948 Convention, including the 11 states that have intervened in these proceedings, and for the court itself. This imposes a particular obligation on counsel to be as careful as possible in dealing with the law and the facts, accurately and objectively, and to be as helpful as possible to the court in your effort to provide the right answers on the important issues that have been raised. These issues include, among others, the legal standards for proving genocide under the Convention, and the nature of the evidence upon which the court may confidently rest its determination of whether those standards have been met. Professor Sands has helpfully laid out our understanding of the existing legal standards for proving genocide, including proof of dolus specialis, as set out and applied by the court in its 2007 judgment in the Bosnia case and the 2015 judgment in the Croatia case. We understand that this is a relatively high standard of proof, and we feel that this is appropriate where allegations of genocide or other grievous international crimes are concerned. This does not mean that the standard set by the court has drawn universal praise. There has been a considerable amount of scholarly commentary about it, some of it critical. This isn't surprising. A few commentators, especially those who have seen the Peace Palace only in photographs, think they know better than you do what the law should be, and they relish telling you so. But that is not what the Gambia thinks. We respect scholarship, but we are not here as commentators. We are here to present our case under the law as your jurisprudence has established it. We do not question or challenge the legal standards you have set. On the contrary, we accept them and argue our case on the basis of those standards as defined and applied by the court in its prior cases under the 1948 Convention. We have no doubt that the evidence we have submitted fully meets those high standards. So we have no need for, nor do we seek, a change in the approach the court has previously established, including, but not limited to, the legal standard for proving genocidal intent. I will explain why this is so by comparing the evidence of genocidal intent in this case with the evidence the court found sufficient to establish genocidal intent in the Bosnia case, and then by comparing it with the evidence the court found insufficient in the Croatia case. Our central submission is that the evidence of genocide, including genocidal intent, in this case is much stronger and much more pervasive than it was in both of those cases. We say that the only reasonable inference that can be drawn from this evidence is that there was an intent by Myanmar to destroy the Rohingya Muslims as a group in whole or in part. My review of the evidence this morning will necessarily be introductory. This speech is intended as an overview of our case. This afternoon and for the 3 days that follow, you will hear a comprehensive presentation of it and how it satisfies the standards set by the court for proving both the actus reus and the dolus specialis of genocide by Myanmar. My intention now is to provide a roadmap that assists you in fully appreciating our presentation and in understanding how each of our speeches, as it is delivered, builds to the inevitable conclusion that Myanmar is responsible for the commission of genocide against the Rohingya Muslim group. With these opening remarks, I turn to the Bosnia and Croatia cases. As we all know, the Bosnia case is the only one in which the court found that genocide was committed. The court found it at one specific location, Srebrenica. The evidence showed that Srebrenica was predominantly inhabited by Bosnian Muslims. After it was taken over by Bosnian Serb forces, those forces separated approximately 7,000 Muslim men from the general population, removed them to a secluded area, and murdered them. As the court explained, quoting from the ICTY's trial chamber in the Krstić case, the perpetrators, quote, systematically targeted Bosnian Muslim men of military age, regardless of whether they were civilians or soldiers. Women, children, and the elderly were spared from death. They were forcibly displaced to other parts of Bosnia. Citing the appeal chamber in the Krstić case, the court found that the killing of such a large number of men, 1/5 of the overall Srebrenica community, quote, would inevitably result in the physical disappearance of the Bosnian Muslim population of Srebrenica. The court concluded on the basis of these facts that the actus reus of genocide under Article 2A and B of the Convention had taken place. The court found, further, that upon capturing Srebrenica and segregating the male population, quote, the Bosnian Serbs devised and implemented a plan to execute as many as possible of the military-aged Bosnian Muslim men in the enclave, and that this was sufficient to satisfy the dolus specialis requirement. The existence of this plan, which was not spelled out in any document, was considered proven by a number of factors identified by the court, namely, the number and nature of the forces involved, the standardized coded language used by the units in communicating information about the killings, the scale of the executions, and the commonality of the killing methods applied. Mr. President, it is our submission that if the court were to apply the same legal and evidentiary standards to the present case, it would have to conclude, as others have done, that Myanmar committed acts of genocide with genocidal intent against the Rohingya Muslim population during its so-called clearance operations in 2016 and 2017. In this case, unlike Bosnia, there were numerous Srebrenicas, that is, massacres of large numbers of Rohingya Muslims to destroy the group, based on their identity as such, carried out by Myanmar's armed forces in multiple locations across northern Rakhine State, where the vast majority of the Rohingya Muslims lived. In other words, what was proven to have occurred at a single site in Bosnia is proven here to have occurred in scores of different Rohingya villages in Myanmar. Many examples are given in our written pleadings, some of which will be discussed in detail by my colleagues. For now, I will call your attention to three of these. The first is Mingi, a village in Mongdaw Township. You can see its location on the map on your screens. Mingi had a population of approximately 4,300 Rohingya and 400 ethnic Rakhine. The UN fact-finding mission found that Mingi was, quote, the location of one of the largest and most egregious mass killings. Myanmar's armed forces, known as the Tatmadaw, commenced their so-called clearance operation in Mingi in the early morning on 30 August 2017. As reported by the UN fact-finding mission, as soon as soldiers entered the village, they, quote, opened fire and began burning houses. They shot directly at crowds of people fleeing to the riverbank or trying to swim across the river. Many of them were killed. Others, especially children and the elderly, drowned while trying to escape. Hundreds of Rohingya who did not manage to get away were trapped and, quote, rounded up on the riverbank. The Tatmadaw then separated the men and systematically executed them with rounds of bullets and killed those who had survived the shooting with large knives. According to the fact-finding mission, the Tatmadaw next, quote, turned to the women and children. Some of the children, continuing to quote, were shot, some thrown into the river, and others thrown onto a fire. An eyewitness recalled seeing around 27 children's bodies floating in the water afterwards. Tatmadaw soldiers then took dozens of women and girls to nearby houses. The fact-finding mission reported, upon arrival, each group was taken to a different room. Once in the room, women and girls were stripped and beaten with sticks, punched or stabbed. They were then raped in groups of up to 7 victims at a time. Many of the women and girls had infants and children with them who were killed or severely injured while their mothers were raped. The houses were then often locked and set on fire, and most victims who were still alive were burned to death. Mr. President, This went far beyond the horrors inflicted during the Srebrenica massacre, where women, infants, children, and the elderly were not attacked. Satellite imagery analyzed by UNICEF confirms the determination by the fact-finding mission that the Rohingya houses and structures in Mingi were, quote, completely burned and destroyed. By contrast, the part of Mingi inhabited by ethnic Rakhine, a predominantly Buddhist ethnic group favored by Myanmar's military regime, quote, remains intact. Destruction of this Rohingya village and many others like it, after killing, grievously wounding, raping, and forcibly displacing the population, reflects even more than an intention to destroy the Rohingya as a population. It demonstrates an obsession with erasing them and their homes permanently from historical memory. The second example is Chatpin, a village in Rautadong Township, shown on your screen now. The clearance operation there took place on 27 August 2017. According to the UN fact-finding mission, quote, hundreds of Tatmadaw soldiers surrounded the village, opened fire, shooting at villagers, including those who were fleeing, dragged people from their houses, shot them at point-blank range, or slit their throats with large knives. An elderly woman described to the fact-finding mission what occurred after she and her 70-year-old brother were pulled from their house. Soldiers used rifle butts to beat my brother on the head, and I saw his brains come out. I saw people being killed with long knives. The soldiers were also spraying bullets, and many people were injured and killed. Our village was full of dead bodies. I saw dozens of people killed. First, they shot the people, and then, if they were still alive and the body was moving, they used a machete to slaughter across the throat. The fact-finding mission found that the Tatmadaw, quote, set houses on fire, including those still occupied. Rohingya victims were, quote, forced inside houses before they were intentionally set alight. The fact-finding mission determined that the Tatmadaw, quote, specifically targeted children, including infants and babies. Quote, some were wrenched from their mother's arms and thrown to the ground. Others were thrown into fire and burned alive. Children and babies. In the aftermath of the assault on Chatpin, witnesses saw, quote, dead bodies everywhere, including those of children floating in the river. No less than 127 children under the age of 6 were slaughtered in Chatpin. As at Mingi, the UN mission found that women and girls were subjected to, quote, rape, gang rape, sexual mutilation, and sexual humiliation, including the mutilation of their breasts. UNICEF's satellite imagery confirms the fact-finding mission's conclusion that, quote, the entire Rohingya village of Chatpin was destroyed, while in contrast, the nearby non-Rohingya village, quote, remains intact. The third example is Mongnu, a village in Buthadong Township. It's shown on your screen now. On the same day as the massacre at Chatpin, villagers awoke to the sight of several trucks full of soldiers arriving with other troops advancing in small groups on foot. They surrounded the village and, quote, whoever ran was shot at. As reported by the UN fact-finding mission, the soldiers approached a compound of 2 large and interconnected houses where approximately 200 Rohingya had sought shelter and ordered the people to come out of the houses or else the buildings would be set on fire. Without waiting, they broke down a door in the main house and fired their weapons into it. Then they, quote, separated women and children from men and, quote, took the men out of the house and tied up their hands behind their backs. A soldier, identified by several witnesses as Sergeant Ba Kyo of the 564th Light Infantry Battalion, after speaking on the phone, told his detachment, quote, "We will kill them." The soldiers then, quote, opened fire on the men and boys and, quote, slit their throats with knives. Similar groups of men were taken to other places in Mongnu, where they were shot or hacked to death. Again, as at Mingyi and Chatpin, the Tatmadaw took special aim at women and girls. Here, too, the UN mission found that many were, quote, gang raped, killed, and mutilated. Employing the same modus operandi as at the other 2 Rohingya villages just discussed, the Tatmadaw burned Mongnu to the ground in the days following the clearance operation. UNISAT analysis of satellite imagery confirms that around 320 structures were destroyed by fire in Mongnu and another nearby Rohingya village. These 3 villages are but a few examples. The evidence shows that Myanmar carried out clearance operations employing similar tactics and methods with the same extreme brutality and sexual violence and devastating effects in many other Rohingya villages in northern Rakhine State, with the gravest incidents having taken place, in addition to the 3 villages I have just discussed, in 4 other locations shown on this map. From north to south, they are Gudarpin, Indin, Khotan Kok, and Chain Kar Lee. In total, the UN fact-finding mission reported that very similar mass atrocities against unarmed and defenseless Rohingya civilians were perpetrated by the Tatmadaw during these clearance operations in at least 54 separate locations. Clearance operations following the same modus operandi took place in numerous other Rohingya villages across northern Rakhine State. The mission verified through multiple interviews and other information clearance operations similar to those detailed above in a total of 54 separate locations, and it received first-hand accounts of additional clearance operations in a further 22 locations. The evidence shows that these were not random acts or the unintended consequences of undisciplined soldiers run amok. The timing and nature of the attacks make this clear. The Myanmar military units were not a group of Serb irregulars who suddenly formed an intention to destroy the Bosnian Muslims who had fallen into their hands after taking Srebrenica. Here, the evidence shows that the Tatmadaw units that deployed to scores of Rohingya villages in northern Rakhine State were following orders from a central military command which planned and directed that the clearance operations be carried out in all of these locations. As at Srebrenica, the genocidal intent of that plan is clearly identifiable from the particular circumstances of its execution. Unlike Srebrenica, Myanmar's plan was carefully and deliberately developed at the highest military level, not spontaneously by irregular forces on the scene. And it was executed across a large number of geographic locations, an even clearer reflection of Myanmar's genocidal intent. There is no doubt that Myanmar's soldiers were acting pursuant to orders emanating from the top of its military hierarchy. Myanmar does not dispute that the Tatmadaw operated under a highly centralized command structure removed from civilian oversight. At its apex was the Commander-in-Chief, Senior General Min Aung Hlaing, who directly commanded the Army, Navy, and Air Force. His authority also extended to all of Myanmar's security forces, including the border police, border guards, and civilian militias. According to the UN fact-finding mission, quote, the Commander-in-Chief led the Tatmadaw General Staff, which was responsible for formulating the objectives and limits of military operations, the role and composition of the forces involved, the rules of engagement, and the necessary logistics. In Myanmar's armed forces, as in the militaries of other states, subordinate officers and units operate pursuant to direct orders from their superiors, deviation from which risks immediate sanction. As Senior General Hlaing himself emphasized, quote, discipline and obedience are the backbone of the Tatmadaw, and each and every serviceman must strictly follow rules and regulations, orders and instructions. Beyond the Tatmadaw's command structure and organization, the existence of a calculated plan, conceived and developed at the highest level, to carry out the clearance operations against the Rohingya Muslims is evidenced by the strikingly similar modus operandi with which these operations were executed all across northern Rakhine State. In dozens of locations, the UN fact-finding mission observed a remarkable similarity in the timing of operations, the sequence of events, the types of weapons used, the assistance received from other security forces or ethnic Rakhine, the coordination and division of roles between perpetrators, the types of violations, and the manner in which they were committed. The modus operandi of these attacks was recognizable and consistent throughout. This could not have occurred. This could not have occurred in the absence of significant levels of forethought and organization. On the basis of this evidence, the fact-finding mission found that there was a, quote, consistent pattern of conduct, which is, quote, only possible when all troops are acting under the effective control of a single unified command, and that their operations have been, quote, planned, ordered, and supervised at the level of the Commander-in-Chief. This is another aspect of our case that makes it much stronger than the Bosnia case. In that case, the court did not find a pattern of conduct from which an intent to commit genocide against a specific group could be inferred. The particular circumstances of the massacre at Srebrenica, which the court did deem sufficient to constitute genocide, were not found to have occurred at other locations in Bosnia. This gives rise to a situation here that was not present in Bosnia, whether in addition to the particular circumstances of the massacres at numerous Rohingya villages, an intent to destroy the Rohingya as a group can also be reasonably inferred from what the fact-finding mission called Myanmar's, quote, consistent pattern of conduct in at least 54 different locations. In addressing this issue, as Professor Sands recalled for you, the fact-finding mission identified 7 factors drawn from the court's jurisprudence and that of other international tribunals, which it regarded as indicators of genocidal intent. And it considered whether these factors were present in Myanmar's clearance operations against the Rohingya. It then found, based on its comprehensive investigation and voluminous evidence, that every one of these 7 boxes could be checked. First, the Tatmadaws' extreme brutality during its attack on the Rohingya. It is beyond dispute that the Tatmadaw conducted the clearance operations with extreme brutality. They killed, maimed, and tortured members of the Rohingya group indiscriminately in a manner that inflicted maximum harm. The atrocities encompassed, among others, large-scale burning of victims alive, often by confining them in homes that were then set ablaze, mutilation with knives, soaking victims in petrol and setting them on fire, and the stabbing, cutting, or fatal beating of infants and young children in the presence of their parents. As regards boys and men, their Srebrenica-style separation and execution was a common feature. Second, the organized nature of the Tatmadaws' destruction. As already noted, the evidence establishes incontrovertibly that the clearance operations were carried out in a highly organized manner, pursuant to a coordinated military plan developed by the Tatmadaws' High Command and approved by the Commander-in-Chief. The clearance operations were thus preceded by careful pre-planning and preparation, and then executed according to plan by similar means across scores of Rohingya villages in northern Rakhine State. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operation. The UN fact-finding mission identified as a, quote, notable pattern the perpetration of, quote, mass gang rape involving multiple perpetrators and multiple victims in the same incident. Victims included children and pregnant women, and the Tatmadaw committed these atrocities with unspeakable depravity, often subjecting the victims to torture and mutilation before killing them. Fourth, the insulting, derogatory, racist, and exclusionary utterance of Myanmar officials and others prior to, during, and after the clearance operations. Myanmar has steadily propagated over decades a racist message that the Rohingya are an impure and subhuman race that originated elsewhere, came to the country illegally, and reproduced so rapidly like animals that they threatened to supplant the pure-blooded national races favored by the government. Myanmar's dehumanizing anti-Rohingya hate speech reached a crescendo during the clearance operations in August and September 2017, when Senior General Hwang, the Commander-in-Chief, spoke of the threat to Myanmar's other races posed by the Rohingyas' mere existence, and gave his assurances that the Tatmadaw would soon be solving the long-standing, quote, Bengali problem, which was until then a, quote, unfinished job. Similar derogatory and threatening racist messages about the Rohingya were disseminated on Facebook, which had widespread reach in Myanmar. The UN's Independent International Mechanism for Myanmar, IIMM, which succeeded the fact-finding mission and supplemented its work, determined that at least 43 Facebook pages were connected to the military and used by the Tatmadaw at the time of the clearance operations, quote, to increase animosity toward the group. Imbued with these messages, Tatmadaw soldiers showed no restraint in their efforts to complete what their commander-in-chief told them was an unfinished job. As one Tatmadaw officer declared, quote, if they're Bengali, they'll be killed. Others, also taking the cue from the commander-in-chief, declared that the hour had come to, quote, kill all the Bengalis and destroy their race so that, quote, none of them should be left alive. Fifth, the existence of discriminatory laws and policies. For years prior to the clearance operations, Myanmar adopted and enforced racist laws and policies that specifically targeted the Rohingya, stigmatized and isolated them, characterized them as mortal enemies of the Buddhist peoples of Rakhine State, and incited violence against them. These official measures included deprivation of nationality and citizenship, restrictions on marriage and childbirth, prohibitions on movement and employment, and confinement in internment camps and ghettos. The UN fact-finding mission found that these openly racist laws and policies, quote, adversely impacted every aspect of their life, including their access to food, livelihood, health, and education. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. Myanmar's senior military and civilian leaders not only tolerated, but actively disseminated vicious hate speech, turning the Rohingya into objects to be feared and despised by other ethnic and religious groups, and inciting those groups to rise up against them. The chief actor was Senior General Hwang himself, who incited Myanmar's Buddhist races against the Rohingya by openly declaring that absolutely our country has no Rohingya race, and warning that, quote, the Bengali population had exploded to the point that it would, quote, swallow them up. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. Despite the enormity of the crimes committed, Myanmar has been unwilling to properly investigate, let alone prosecute the perpetrators. Instead, it has steadfastly refused to cooperate with impartial international agencies, including from the United Nations, and it has invested heavily in destroying evidence, including by razing the remains of the Rohingya villages where the genocide occurred. True to its nature as a de facto military government, Myanmar has cloaked its armed forces in an impenetrable gown of impunity. After reviewing the evidence of Myanmar's conduct under these 7 headings, the UN fact-finding mission concluded in 2019. Every one of these indicators is linked to the acts or omissions of Myanmar state organs, including the military, other security forces, ministries, legislative bodies, the UEHRD, and other civilian institutions. Collectively, they demonstrate a pattern of conduct that infers genocidal intent on the part of the state to destroy the Rohingya in whole or in part as a group. For reasons explained in its 2018 report, there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. In sum, the evidence of genocide, including genocidal intent, is not only much stronger and much more pervasive in Myanmar than it was in Bosnia, but it was determined by the fact-finding mission to permit no reasonable conclusion other than genocide. Instead of a single Srebrenica, there were multiple villages where similar massacres of Rohingya Muslims took place. Instead of a renegade Serb militia whose action the court was unable to attribute to a state, in Myanmar it was the state itself through its armed forces which perpetrated these atrocities. Instead of an impromptu intent formed immediately prior to the genocidal acts, in Myanmar there was a plan prepared well in advance of the clearance operations at the highest level of the armed forces and dutifully executed by subordinate officers and enlisted personnel throughout northern Rakhine State, employing the very same modus operandi. In Myanmar, in contrast to Bosnia, genocide, including genocidal intent, is proven not only by particular circumstances in particular locations, but also by a pattern of conduct demonstrating the existence of a plan, the intent of which it can only reasonably be inferred from its nature and the manner of its execution was to destroy the Rohingya as a group. Mr. President, the evidence before you also distinguishes the present case from the Croatia case. In Croatia, the court found neither particular circumstances, nothing equivalent to the massacre at Srebrenica, for example, nor a pattern of conduct from which genocidal intent was the only reasonable inference to be drawn. The case is nevertheless helpful to us here for several reasons. First, the court found that the actions of the respondent state constituted a pattern of conduct, evidenced by what it called, quote, similarities in terms of the modus operandi used between some of the attacks confirmed to have taken place, end of quote. These similarities included attacking and occupying Croat localities and creating what the court called, quote, a climate of fear and coercion by committing a number of acts that constitute the actus reus of genocide within the meaning of Article 2A and B of the Convention. Finally, the occupation would end with the forced expulsion of the Croat population from these localities, end of quote. By the same reasoning, the evidence in our case plainly establishes a pattern of conduct by Myanmar across the expansive geographic area in which the majority of Rohingya lived in northern Rakhine State. As you have seen, this was the conclusion reached by the UN fact-finding mission. Second, To determine whether genocidal intent could be reasonably inferred from the respondent state's pattern of conduct, the court considered factors that largely overlap those employed by the UN fact-finding mission in our case, and which the mission concluded were indisputably present in our case. According to the court, the most important factors in revealing a genocidal intent were, as Professor Sands recalled earlier, 1, the scale and alleged systematic nature of the attacks. Check. 2, the attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. Check. 3, the specific targeting of Croats, in this case, the targeting of Rohingya Muslims. Check. 4, the nature, extent, and degree of the injuries caused to the Croat population. Again, substitute Rohingya Muslim for Croat and check. The court did not find that all of these factors were present in Croatia, but they are all undeniably present in our case. Third, and this is the feature that most distinguishes Croatia from our case, the court found that Serbia's policy was to establish an ethnically homogeneous Serb state, following the forced displacement of Croats from the parts of Croatia that Serbia hoped to annex, or at least control. The court found it determinative that this intention, quote, namely the forced displacement of the Croats, did not entail their physical destruction. It was not a question of systematically destroying that population, but of forcing it to leave the areas controlled by these armed forces. In other words, for the court, Croatia v. Serbia was a case of ethnic cleansing, but not genocide. To be sure, the one does not necessarily exclude the other. In the Bosnia case, the court explained that, quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention, and may be significant as indicative of a specific intent, dolus specialis, inspiring those acts. However, in the Croatia case, the court did not consider that Serbia's ethnic cleansing of Croats was indicative of an intent to destroy them as a group. Its findings were to the contrary. It concluded that, quote, Croatia has not established that the only reasonable inference that can be drawn from the pattern of conduct it relied on was the intent to destroy, in whole or in part, the Croat group. This further distinguishes the Croatia case from our case. Myanmar's pattern of conduct, in contrast to that of Serbia, does not permit the court to reasonably infer that its intent was to forcibly displace or ethnically cleanse the Rohingya Muslim group. Myanmar itself does not claim that this was its intent, or that such an intent can be reasonably inferred from its conduct. In fact, Myanmar has consistently denied this. To be sure, Myanmar's clearance operations caused massive forced displacement, in addition to killing, maiming, and raping of the Rohingyas. As the court explained in Croatia, the existence of genocidal intent in such circumstances depends on whether, quote, the forced displacement was carried out in circumstances calculated to result in the total or partial destruction of the group. The evidence in our case shows plainly that it was, as the fact-finding mission concluded. As Professor Sands told you, Myanmar argues that the clearance operations were intended neither to forcibly displace, ethnically cleanse, or destroy the Rohingyas as a group. Its only defense of this conduct is to claim that its actions were intended to combat terrorism, specifically to counter the activities of the Arakan Rohingya Salvation Army, referred to by the acronym ARSA throughout the pleadings. The clearance operations were exercised in counterterrorism against ARSA, says Myanmar, not efforts to destroy the Rohingya as a group. This is, frankly, a hopeless argument that is entirely unsupported by the evidence. But in the circumstances, it appears to be the best defense that Myanmar can gin up. And we will give it due attention over the course of our presentation this week, including with a speech on Wednesday devoted entirely to this issue. For now, as a sort of preview, I will simply make 3 points about it. First, it is fundamental and should not be debatable that actual counterterrorism is based on ensuring the safety and security of the affected population and gaining its loyalty and support. This cannot be reconciled with sending the armed forces to scores of villages, setting fire to homes with families still inside them, shooting at everyone who moves, rounding up men and boys for mass execution, hacking children and infants to death, raping, gang raping, and mutilating women and girls before killing them, forcing survivors to run for their lives, and then razing their villages to prevent them from returning. This is what the evidence shows Myanmar did, and it is a description of genocide, not counterterrorism. Second, this is not a case, as Myanmar has argued in its written pleadings, of applying Western standards to a less developed country in the global South. Yes, our expert witness, Professor Michael Newton of Vanderbilt Law School, from whom you will hear next week, is a retired U.S. military officer. But he has devoted both his military and academic careers to the law of war and particularly to matters of counterterrorism, including in non-Western and developing states. His expert testimony is that the fundamental principles of counterterrorism strategy and tactics are nearly universally accepted, including most significantly by Myanmar itself. This is reflected in the Tatmadaws' own rules of engagement, which Myanmar has very helpfully attached to its pleadings. There is no problem with these rules, according to Professor Newton. The problem is, as you will be shown by my colleagues, that Tatmadaw completely ignored them in carrying out its clearance operations against the Rohingya. Most prominently, as the UN fact-finding mission concluded, the killing of civilians is inherently brutal in any context. The perpetrators of the clearance operations in Rakhine State introduced an additional dimension to this. There was not the least effort to make any distinction between ARSA fighters and civilians, or to specifically target a military objective or identify and repel an immediate threat. Everyone was a target, and no one was spared. Mothers, infants, pregnant women, the old and infirmed, all fell victim to the ruthless campaign. The targeting of women and girls for rape, gang rape, and other forms of sexual violence, as well as the targeting of and impact on children in general, has been shocking. The brutality with which the underlying acts were carried out provides further support for a conclusion that they were committed with genocidal intent. My third point is that the clearance operations were by several orders of magnitude far out of proportion to what was needed to defend against arson. This is how the UN's independent investigative mission for Myanmar described ARSA's capacity in August 2017 when Myanmar launched its clearance operations. Based on photographs and videos released by the Myanmar military, publicly circulated footage, witness testimonies, and official statements, the mechanism found that by August 2017, ARSA likely possessed a modest arsenal of 40 to 70 firearms of mixed types and calibers. Most ARSA members primarily used bladed weapons, sticks, and a limited number of artisanal firearms. While IEDs appear to have been used in the 2016 and 2017 attacks, there is no conclusive evidence that firearms were employed. It is not surprising that Myanmar would attempt to transform ARSA, armed mainly with knives and sticks, into a major fighting force and national security threat. To be sure, we do not suggest that Myanmar should have ignored ARSA. As a sovereign state, it had the right to defend itself against such an outfit, even if it was as poorly equipped as the evidence shows. However, history teaches us that when genocide occurs, it is almost always under cover of armed conflict. In this regard, it would be wise to recall the words of Judge Cansado Trindade in the Croatia case, partially quoted by Professor Sands. One cannot characterize a situation as one of armed conflict so as to discard genocide. The two do not exclude each other. In this connection, it has been pertinently warned that perpetrators of genocide will almost always allege that they were in an armed conflict and that their actions were taken pursuant to an ongoing military conflict. Yet, genocide may be a means for achieving military objectives, just as readily as military conflict may be a means for instigating a genocidal plan. Before concluding my presentation, I'd like to call attention to one more distinguishing feature from the present case and both the Bosnia and Croatia cases. In the prior cases, the court had the benefit of findings of fact by another international judicial body, namely the ICTY. To be sure, the court did not rely on those findings exclusively. In Bosnia, the court found helpful a report by the Secretary General on the fall of Srebrenica, describing it as having considerable authority because of the care taken in its preparation and the independence of those responsible for it. Likewise, in Croatia, the court found that it must give evidential weight to a report by the UN Special Rapporteur by reason both of the independent status of its author and of the fact that it was prepared at the request of organs of the United Nations for purposes of the exercise of their functions. Here, the centerpiece of our case has been from the very beginning the two voluminous reports consisting of more than 600 pages prepared by the UN fact-finding mission appointed by the Human Rights Council, which were published in 2018 and 2019. These too are notable for the care taken in their preparation and the independence of those involved. The evidence contained therein has been supplemented in the course of these proceedings by numerous equally independent and authoritative reports from the IIMM, other United Nations bodies, impartial non-governmental organizations, and various states, as well as 48 sworn statements from eyewitnesses, all consistent with the conclusions of the fact-finding mission, and all supportive of the Gambia's submission that Myanmar acted with genocidal intent in carrying out its clearance operations against the Rohingya in 2016 and 2017. Mr. President, members of the Court, I will speak again at the beginning of this afternoon session, delving further into the reliability of the sources of evidence on which the Gambia replies. And in the interest of time, I will simply conclude this presentation now by thanking you for your kind courtesy and patient attention, and asking that you call my good friend and esteemed colleague, Mr. Arslan Suleiman, to the podium.